am Durga Devi Rajendran. I am here to explain the summary of the case between Rani Periasamy and PTZ Shipping Agency Sindrian. Based on the case that I refer, this case mainly about company's dormant status. Rani Periasamy is complainant of this case and PTZ Shipping Agency Sindrian Berhad is the respondent of this case. This is a complaint of non-compliance pursuant to forms filed under Section 56 of the Economic Relations Act 1967 and Rule 24 of the Economic Court Rules 1967 on 13 September 2019 within the matter of commercial court. A complainant is hereby lodged by the complainant that the provisions of the above mentioned award haven't been complied within the respect of paragraph 74, where the court orders the corporate to pay to the claimant the sum of 115,440 ringgit within 30 days from the date of this award. The complainant within the statement of case filed on 4th November 2019 was that the appliance of review by the respondent in Malaysian Capital State Supreme Court for an order of statutory to quash the said award was dismissed with cost on 14 May 2019. The complaint was that thus far the respondent has not complied with the said award. Wherefore, the complainant prays for an order that the respondent complies with the said award. The respondent within the statement back filed on March 2019 was that the parent company, PTZ Holdings Berhad, is now operated with the administrators only and also company's subsidiary. Only operated with 6 staffs and also the instant company is within the dormant status with no staff, no enterprise or receiving any style of revenue. The respondent explained that pursuant to the tribunal order, the respondent has filed an application of stay of execution pending the disposal of the notice of appeal filed on 10 June 2019 at the Court of Appeal on 1st November 2019, and therefore the hearing of this notice of application was fixed on 13 November 2019. The paramount consideration governing an application for a stay of execution is that the appeal to the current court, if successful, should not be rendered negatory. If upon balancing all the relevant factors, this court involves the conclusion that an appeal will be rendered negatory without the grant of a stay or other interim preservation order, then it should normally direct a stay or grant other appropriate relief that has the effect of maintaining the establishment. The complainant's counsel submits that it's settled law that an appeal doesn't operate as a stay. The counsel is leaving to the court for the choice on the applying for postponement by the respondent. The court will direct this application to proceed within the interest of justice under Section 29 of the Commercial Relations Act 1967, whereby the court will generally direct and do all things as are necessary for expedient for the expeditious termination of the matter before it. The complainant prays for an order that the respondent complies with the said award for the sum to be paid within 40 days from the date of this award. The respondent submit that the non-compliance by the respondent arose due to the review stay application additionally because the notice of appeal filed at the Court of Appeal. During this application before this court, the respondent's counsel has not demonstrated that there is an irreversible consequence which may affect the respondent if the Court of Appeal were to come to a decision the appeal in favor of the respondent. In any event, The hearing of the notice of application has to be heard, and whether or not heard, the choice is also deemed academic within the light of the notice of appeal to be heard within the court of appeal earlier. In arriving at this decision, the court has acted with equity, good conscience, and therefore the substantial merits of the case without relevancy, technicalities, and legal form. The order of complaints is hereby allowed. The court unanimously orders the respondent to pay the complainant the sum of 115,440.
Good day everyone, I'm Prasanna Kai Silvan here to explain about the fact of the case in this video. So let's go! Firstly, as the report dated 2nd July of 2018 between Rani, daughter of Periyasamy versus PDZ Shipping Agency Sindran Berhad. The claimant, contrary to the conditions provision of the above award, was not complied within respect of paragraph 74, except that the award was complied within in accordance with paragraph 74. The court was ordered the corporation to pay the amount of ringgit Malaysia 115,440 to the complainant within 30 days of this award. First, in the declaration of case filed on 4th November 2019, the plaintiff disagrees that the appeal of the respondent's judicial review in Kuala Lumpur High Court for an order of certiorari to quash the award was rejected. On 14th May 2019, with charges, the plaintiff was aware that the respondent has not met with the said award to date. The plaintiff then prays for an order complying with the said award from the respondent. In the declaration in reply filed on 11th November 2019, the respondent expressed aversion. The parent company, PDZ Holding Sindran Berhad, is now run exclusively by directors and a subsidiary of the company. Beta Marine Sindran Berhad, they only collaborated for 6 people, and the present corporation is in an inactive state with no employees, no commercial operation, or any sort of profit. In the declaration in reply filed on 11th November. Lastly, the respondent clarified according to the order of the High Court, pending the disposition of the notice of appeal logged at the Court of Appeal on 10th June 2019 until 1st November of 2019. The respondent filled an application was scheduled for 13th November 2019.
Hai, Assalamualaikum warahmatullahi wabarakatuh. friend. I'm Fatimah Sarah binti Minhad. I want to explain about related the case we act. This case is a complaint of non-complaints filed in accordance with Form S pursuant to Section 15(6) bracket 1 of the Industrial Relations Act 1967 and Rules 24A of the Industrial Court Rules 1967 of 13 September 2019. In case number 29 bracket 5 bracket 4 627 bracket 17 of the Industrial Court Awards number 1462 of 2018 of July 2018 between Rani Anak Perempuan Periyasami v. PDS Shipping Agency Sdn Bhd. To give judgment, the court should take account of the public interest, the financial consequence and the impact of the award on the economy of the country and the industry concerned, as well as the probable effect on the related or similar industry. In making its award in respect of commercial dispute, the court should without regard the technicalities and legal form, act on the basis of equity, good faith and the substantive merits of the case. The court may, in making its awards, take into account any agreement or code relating to employment practice between employers, representative organization and employees, where the agreement or code has been. The complaint is lodged by the complainant that the terms of the above awards have not been complied with in relation to paragraph 74, whereby the court direct the corporation to pay the amount of Rm 115,440 less statutory deduction, if any, to applicant within 30 days of the date of the award. The counsel of the plaintiff claims that it is settled law that an appeal does not act as a stay. The lawyer shall leave the respondent to the court for a decision on an appeal for postponement. The court shall order the application to proceed in the interest of justice pursuant to Section 29 bracket G of the Industrial Relations Act 1967, whereby the court shall, in general, guide and do all that appropriate for the expeditious determination of the matter before it. For the Act of 15(6) bracket 1 of the Industrial Act 1967, non-complaints with award of collective agreement. Any complaint that any term of any award or of any collective agreement which has been taken cognizance of by the court has not been complied with may be lodged with the court in writing by any trade union or person bound by such award or agreement, and rules 2A. Notwithstanding the provisions of subsection 33 bracket 1, the court shall, upon making the order under subsection bracket 2, have the power to interpret any matter relating to the complaint made. For the amount to be paid within 14 days of the date of this award, the claimant prays for an order that the respondent complies with the said award. The respondent submits that the failure of the respondent to comply was due the judicial investigation, the stay application, and the notice of appeal filed at the Court of Appeal. In this application before this court, the respondent counsel have not demonstrated that there is an irreversible consequence which can affect the respondent if the Court of Appeal were to decide the appeal in favor of the respondent. In any event, the hearing of the notice of application has yet to be heard, and even if heard to, the decision may be deemed academic in the light of the notice of appeal to be heard in the Court of Appeal yearly. And then, the court may upon receipt of the complaint make an order directing any party to comply with any term of the award or collective agreement, or to case or decide from the doing any act in contravention of any term of the award or collective agreement, makes such order as it deems fit to make proper restitution for any contravention of any term of such award or collective agreement, or makes such order as it consider desirable to vary or set aside upon special circumstance any term of the award or collective agreement. All proceeding at an awards commissions done or made under the written laws hereby repealed shall have effect for all purpose as if these proceedings, acts or awards were commenced, done, or made under this act, and is as if this act has then been enforced. He court or tribunal before which the proceeding were commences shall continue in existence, and the term of appointment of all members thereof, including the president and the chairman, shall be deemed to have been extended until the final disposal of the subject matter of the proceeding, and that any vacancies in the court of tribunal shall be filled in accordance with the act. As if the court or tribunal had been appointed under this act, all agreement deposit until any written law repealed shall be deemed to be collective agreements deposit with and taken cognizance of by the court under this act. The last one. In making the decision without regard the technicalities and legal form, the court act with equity, good faith, and the substantive merits of the case. The enforcement order is approved hereby. The court unanimously order the respondent to pay the amount of 115,440 immediately to the claimant. In the event of agreement being reached during the proceeding before the court in making it award may, subject to the acts, have regard to the term of the agreement, and in the event of an agreement being reached before the court commences its proceeding, the court may be constituted by the presiding or chairman sitting alone of the purpose of recording the term of such agreement. That's all from me. Thank you.
Hello madam, my name is Chaisri Paramasingham. Today I would like to explain about the comment on the cases, which is the pros and the cons. First one is it's fairly easy and free. Presenting a case is much more secure and can hear and give over choices or grants in modern questions alluded to it by the minister or straightforwardly by the parties. The second one is fast processing in industrial code, which means industrial code provide an efficient case study on disposing dismissal cases which have been referred to the industrial code within 16 months and other cases within 12 months. Also, to hand down award within 3 months from the date of the late submission, and to accord cognizance to collected agreements within 6 weeks of deposition with the court. Number 3 is standing up for the claimant, belief and what she owned to the company, which means in the event that the inquirer been dealt with severally or our own cash, some of the time the correct thing do it additionally the harder activity. The petitioner demonstrating that standard which reasonable treatment merit battling for alongside any pay or own monies. From the case, the petitioner went to the organization premise and market a conversation letter under dissent as she been conserved from the organization, were gotten an email from the managing director requiring a gathering which was planned on 11th December 2018 between 3 p.m. to 3:30 p.m. On 11th December 2018, the managing chief educated the claimant that she was saved from administration without a legitimate reason. Number 4 is it doesn't need to cost the claimant a fortune. Nowadays, petitioner need not bother with costly legal counselor to battle for their case. Modern legal dispute are considerably less formal than courts, and judges will be thoughtful and listen. All the needs an inquirer to do is show where she have endured a wrongdoing. The court and assist with articulating the focus and arranging the proof. Second part which I would like to discuss is about the pros and cons, which is the summary. From this finding of this case, in view of the proof, both narrative and oral declarations of the observed that the organization has neglected to demonstrate on the equilibrium of probabilities that there is genuine and bona fide access for these situations. These assertions gave the organization and the often party a negative effect, as the PDZ shipping agency has neglected to deliver any contemporaneous narrative proof in the court to show how the choice was taken for the affirmed rebuilding and the premise on which the claim was picked to the end. From the positive view, the claimant has argued for a request that be restored to his previous situation with no deficiency of status, wages or benefits, money related or something else, along with unpaid debt of pay and from the date of excuse to the date of restorations or in the elective pay in lieu of re-establishment. The court should, regardless of details and legal form, follow up based on value, great confidence and the considerable benefits of the case. The court may, in its making its honor, consider any agreement or code identifying with work rehearsals between businesses, delegate organizations and employees where the agreement or code has been endorsed by the minister. Thank you.
My name is Susan Calvina and I'm a BHRM student. So today I'm here to present about solution based on the assignment that given to me, case study. It's about PDZ Shipping Sdn Bhd, whom the complainant is Rani Anak Perempuan Periasami. So let's get into the slide to get the summarization of the solution today.
So the solution of this case is: employee from PDZ Shipping Agency Sdn Bhd, Rani Anak Perempuan Periasami, should be resolving the problem with PDZ Shipping Agency Sdn Bhd before make a complaint at Kuala Lumpur High Court. The claimant, contrary to the condition of the provisions of the above award, was not compiled within respect of paragraph 74, except that the award was compiled within accordance with paragraph 74. The court ordered the corporation to pay the amount of 115k ringgit to the complainant within 30 days of the date of this award. They can be bring this problem directly to the employer for settle in the office,
Once the claimant, which is Rani Anak Perempuan Peresami, don't agree the Human Resource Department's opinion, then they can bring the issues together with the claimant to Department of IR, which is Department of Industrial Relation, as we all know. They must advising her of their right to accompany, and the reason should be necessary to be explained in the private room of the organization. They can be communicate, and she will be share her opinion of the issue. And finally, they should be give the employee a right of appeal her decision. If the employer don't agree with her decision, then she can bring this issue to Department of Industrial Code. Let's say if the employer don't agree with her decision, then she can bring this issue to Department of Industrial Code. But the managing director of PDZ Shipping Agency Sdn Bhd don't follow this procedure. He must follow the Act of 56 of the Industrial Act 1967, which is non-compliance with award or collective agreement. Any complaint that any term of any reward or of any collective agreement which has been taken cognized by the court has not been compiled with may be lodged with the court in writing by any trade union or person bound by such award of agreement and rules. The organization don't want to go to the court. They say it can be solved in a short period by Department of Industrial Relations because the respondent explained the pursuant to the tribunal order. The respondent has filed an application of stay execution pending the disposal of the notice of appeal filed on 10 June 2019 at the Court of Appeal on 1st November 2019, and therefore the hearing of this notice of application was fixed on 13 November 2019, and there not a court hearing. If they can't settle the problem there, the issue will be referred to the Minister of Human Resource Management, who has the power of discretion to decide whether or not to refer the matter to the Industrial Court. So that Ms. Rani Anak Perempuan Peresami can consider the Industrial Court about the employee dormant status her with giving a valuable reason within 60 days from 31st December 2018. They will be take actions such as follow with the department's procedures. They will be arranging a conciliation meeting between the claimant, Ms. Rani Anak Perempuan Peresami, and the employer of PDZ Shipping Sdn Bhd. An industrial relation officer will act as a mediator between the claimant and employer in hopes that the matter can be settled easily at the room of meeting. Thank you very much.